We have Neal Manne, Steve's longtime friend and partner, who's going to introduce Steve. And Neal, please, take it over.
Thank you. Well, thank you very much. It's my pleasure and honor to introduce Steve as the recipient of the 2018 Alan Van Fleet Award. Before I do that, I want to recognize not a public official yet, but a very special candidate, Steve's and my partner, Justin Nelson, who is the Democratic candidate for Attorney General. And Justin is, of course, the only candidate for Attorney General in the entire state who is not currently under indictment. Go Justin. Clarence Darrow once said that the only real lawyers are trial lawyers. And trial lawyers try cases to juries. If that's right, then for more than 50 years, Steve Susman has been a real lawyer. I doubt that in Clarence Darrow's time there was any concern about the disappearance of the jury trial, though some jurors may have wished there were. Darrow made jury arguments that lasted not for hours, but sometimes for days. You saw reference in the skit to the Big Bill Haywood murder trial. Darrow's closing argument in that case lasted 12 hours. Haywood was acquitted. In the Leopold and Lowe murder trial, where guilt was not the issue was whether there would be a death sentence imposed or only life in prison, Darrow's closing argument lasted for 3 days. And both of them, as you saw, avoided the death penalty. Now, did you notice Steve perk up when I mentioned a 3-day closing argument? He likes that idea. Now, the quiz. Who knows how long Darrow's closing argument was in the Scopes monkey trial that we just heard about? Come on, anybody, shout it out. How long was it? 0. He waived closing argument so that Brian couldn't give closing argument either. No closing argument. Truly Steve Susman's personal nightmare. Steve has spent his career not just trying big cases to juries, but working tirelessly to preserve the institution of civil jury trials. In the 1990s, as chair of the Texas Supreme Court's Discovery Advisory Committee, Steve helped craft new rules to streamline discovery in cases. Most of those proposals were adopted and are now part of our civil rules. He was an active member of an ABA task force that wrote the original civil trial practice standards. As a member of the Federal Circuit's Committee on E-Discovery, Steve helped devise sensible limits on electronic discovery in civil cases. Later, he co-chaired a task force in the Southern District of New York, which implemented a pilot project for expediting civil jury trials. He has created a website, write this down if you don't know it, trialbyagreement.com, a web page on which Steve has for a long time now promoted a series of agreements that lawyers in civil cases, opposing lawyers, can voluntarily agree to in order to simplify, make less expensive, and make a better experience for jurors civil jury trials. His passion for jury trials is deeply rooted. Steve clerked on the U.S. Supreme Court for Justice Hugo Black. Justice Black was the Supreme Court's staunchest advocate of the Seventh Amendment and the right to trial by jury. In 1939, Justice Black wrote, "It is essential that the right of trial by jury be scrupulously safeguarded as the bulwark of civil liberty." And nearly 80 years later, Steve Susman is the heir to that vision. For the past 3 years, Steve has spent a lot of his time leading the Civil Jury Project at NYU Law School, which he not only founded, but funded. What began as an idea that Steve would bend our ears about at cocktail parties has, in 3 years, grown to be a very vibrant enterprise. The only academic project in the entire country focused on studying, preserving, and improving jury trials. There are 275 state and federal judges across the country who have signed on with Steve to this project and serve as judicial advisors, along with 65 law professor academic advisors and 35 different jury consultant advisors. Steve travels across the country lecturing on the work of the project, especially on how to improve the experiences of jurors. Though he spends a huge amount of time on these unpaid public service efforts, Steve certainly has not taken off his trial lawyer boots for the last time. At 77 years young, he is still actively trying cases, affording the lawyers, especially the young lawyers at our firm, the really incomparable opportunity to go to court and try a case with one of the true legends of our profession. Though we all have our own styles in the courtroom, there's not a lawyer at Susman Godfrey who hasn't stolen a few tricks from Steve about how to analyze a case, how to prepare it for trial, and how to present it to a jury. Just as Herman Melville's Captain Ahab was ceaseless in his quest for the great white whale, Steve tirelessly continues his quest for a bigger, bolder, and more badass verdict in some courtroom somewhere. My law firm colleagues were thrilled last week when Max Tribble won a $710 million verdict from a San Antonio jury. It was good news. It was good news for a couple of reasons. First, it obviously was good news because Max has a very expensive lifestyle. And this is gonna kind of fund him for a little while going forward. But mostly we were happy with the size of this verdict because we, Steve's partners, recognized instantly what this meant. It killed any risk that Steve Susman was going to quit practicing law anytime soon. He's a little bit competitive, and there's no way that he's not going to keep going now until he has rung up yet another huge verdict somewhere, bigger than Max's. And that is a great thing, because no one really in modern times has worked harder or done more than Steve Susman to focus attention on the jury trial and worked harder to preserve it and improve it. Because of that, no one more than Steve would be worthy of an award like this one, named after such a legendary trial lawyer as Clarence Darrow. So please join me in congratulating Steve Susman.